courts regulate rights of U.S. citizens. It is the duty of the court to recognize the substance of things and not the mere form. The courts are not bound by mere form, nor are they to be misled by mere pretenses. They are at liberty indeed, they are under a solemn duty to look at the substance of things, whenever they enter upon the inquiry whether the legislature has transcended the limits of its authority. If, therefore, a statute purported to have been enacted to protect the public safety has no real or substantial relation to those objects, or is a palpable invasion of rights secured by the fundamental law, it is the duty of the courts to so adjudge and thereby give effect to the Constitution. Mulger v. Kansas, 123 U.S. 623, 661. And it is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon. Boyd v. United States, 116 U.S. 616. The courts are duty-bound to recognize and stop the stealthy encroachments which have been made upon the citizen's right to travel and to use the roads to transport his property in the ordinary course of life and business. Hadfield, Supra. Further, the court must recognize that the right to travel is part of the liberty of which a citizen cannot be deprived without specific cause and without the due process of law guaranteed in the Fifth Amendment. Kent, Supra. The history of this invasion of the citizen's right to use the public highways shows clearly that the legislature simply found a heretofore untapped source of revenue, got greedy, and attempted to enforce a statute in an unconstitutional manner upon those free and natural individuals who have a right to travel upon the highways. This was not attempted in an outright action, but in a slow, meticulous, calculated encroachment upon the citizen's right to travel. This position must be accepted unless the prosecutor can show his authority for the position that the use of the road in the ordinary course of life and business is a privilege. To rule in any other manner, without clear authority for an adverse ruling, will infringe upon fundamental and basic concepts of constitutional law. This position, that a right cannot be regulated under any guise, must be accepted without concern for the monetary loss of the state. Disobedience or evasion of a constitutional mandate cannot be tolerated, even though such disobedience may, at least temporarily, promote in some respects the best interests of the public. Sloat v. Examination, 112 ALR 660. And economic necessity cannot justify a disregard of constitutional guarantee. Riley v. Carter, 79 ALR 1018, 16 AM, Jur. 2nd. Constable Law, Sec. Point 81. And constitutional rights cannot be denied simply because of hostility to their assertions and exercise. Vindication of conceded constitutional rights cannot be made dependent upon any theory that it is less expensive to deny them than to afford them. Watson v. Memphis, 375 U.S. 526. Therefore, the court's decision in the instant case must be made without the issue of cost to the state being taken into consideration, as that issue is irrelevant. The state cannot lose money that it never had a right to demand from the sovereign people. Finally, we come to the issue of public policy. It could be argued that the licensing scheme of all persons is a matter of public policy. However, if this argument is used, it too must fail, as no public policy of a state can be allowed to override the positive guarantees of the U.S. Constitution. 16 AM, Jur. 2nd. Constable Law, Sec. Point 70. So even public policy cannot abrogate this citizen's right to travel and to use the public highways in the ordinary course of life and business. Continued in Part 2 of this series.